Hi everyone, I'm Wisconsin elder law and estate planning attorney Vince Hein, and in this video I'm going to talk about living trust and why when you do one you still need a will. So somewhat of a common misconception is people think when they do a trust they just do a trust and that's that. What really happens is when you do a trust, generally it's part of a package where you're doing powers of attorney and things like that as well, and getting real estate and other assets deeded into or transferred to the trust. But when you do a revocable living trust, for example, you're always going to have a will, or pretty much always, and it's going to be what's called a pour-over will. Think of a pitcher of water pouring into a glass. What it really says is, at my death, if it's not in my trust, put it in my trust, right? And because that's how we catch something that maybe got left out, we didn't know about, you got an asset later on that was a probate asset. And so that pour-over will catches that asset and moves it to the trust. Now, unfortunately, if that will ultimately is what's used to sort of catch that asset, then you are still going to go through a probate, but that's a different situation. So when you do a trust, you do a will also. Again, think of that pitcher of water pouring into a glass, and your will is going to be exactly like that. If you do an irrevocable trust, it might be like that, but it might say to my spouse and then to the irrevocable trust because it's going to be locked up once it goes in there. So if you do a will only, generally then you're not doing a trust, but if you do a trust, you're also going to be doing a will. Hope you found this video helpful. I'm attorney Vincent Hein. Thank you so much for watching.